Cheryl Brown.
Hello, thank you for this opportunity. I sat in the LOB and provided testimony on January 11th, 2008 regarding the unmet therapeutic needs of my 3 beautiful adopted special needs children. I'm saddened to report the family and child serving systems of our state did not help us, and that includes the courts. We are virtually one of the poster families for the topics being addressed today. When a family reports to court with DCF for custody, there's a pre-court conference conducted in a separate room by a court services officer. Participants in that conference, as Stella mentioned, are the AAG, the parents' attorney, and DCF, but not the parents. It must be known the parents are the only ones left in the hallway. They are the only ones paying to be there, as well as being required to take time off from work. And Stella got me all wound up and emotional. If my attorney is admitted as my representative without me, then why isn't the AAG admitted to represent their client DCF without them? This is an unfair, disrespectful practice occurring daily, to which even the court services officers object. Who then is dictating this practice? The results of the pre-court conferences are presented to the parents in the hallways as edicts, all negotiated and ready for us to sign, with no voice on content or understanding of others' positions on their decisions and how the specific steps are designed to help our children and our family. I cannot think of a better way to destroy a family, child's trust and faith in their parent than through DCF intrusive investigations designed to alienate them from their parents' authority. For my children, this occurred with their biological parents and then with me, their adoptive parent. Given that DCF put us together as an adoptive family in 2003, I have repeatedly asked, where's the support and partnering needed to keep us together? It is DCF, not me or my children, that wanted us taken apart. DCF formed our family in 2003, with our adoptions finalized in 2006. Over the years, DCF put us through 16 unsubstantiated investigations and 6 custody court cases. DCF took 2 of my 3 children into custody twice, I retained custody twice, and DCF revoked custody twice. 2 of my 3 children were taken into custody at age 16 and were then dropped by the departments at age 19. My 19-year-old son is currently living on the streets. I'll close with a story, and I hope you realize I've addressed a few of these topics. The last one is regarding privacy as well as practices. My daughter, I have 3 children. My daughter, number 1, was in Riverview. Daughter number 2 and my son were in psychotherapy, and one evening they became overwhelmed, resulting in both being taken for suicidal ideation evaluation by ambulance to separate ERs. The very next morning, our existing DCF, Special Mental Health Services LCSW, went to Riverview unscheduled. He checked in with no one, walked onto the unit and walked up to my daughter and said, "So, what do you think about your brother and sister now also being inpatient?" My daughter then spent the next 72 hours flipping out. Remember, this trained and credentialed DCF LCSW, who knew my daughter and family fairly well, clued in no support for my daughter before sharing extremely volatile information with her. My daughter was still flipping out and actively self-harming, unable to sleep or regulate herself at all for 72 hours, while her brother and sister were over their events and were back home. While this social worker went about his life and job, it needs to be said that per DCF guidelines and regulations, if I, the involved and loving parent, had shared our family info with my daughter as he had done, I would have been investigated and substantiated for emotional abuse of my daughter. Thank you.